Good morning and welcome to the Ninth Circuit. The first case we will hear today is Pacheco versus Bondi.
Good morning, Your Honors, and may it please the Court. Diana Sanchez, on behalf of Petitioner Jose Pacheco, I would like to reserve 3 minutes and I will watch my time.
Thank you.
Mr. Pacheco is deaf, has a moderate intellectual disability, and severe mental illnesses. He's experienced an extreme language deprivation and social isolation that has impacted his development permanently and contributes to his limitations today. During his proceedings, Mr. Pacheco repeatedly requested a certified deaf interpreter and a sign language interpreter because he cannot communicate effectively with only the sign language interpreter. The agency granted this request but neglected to follow through, and in doing so made several legal errors. The agency's affirmative obligations under the Act provide multiple grounds to grant the petition and remand for a new hearing, and for substantially the same reasons, the court can also grant based on the denial of due process. But because of Mr. Pacheco's several disabilities, the Rehabilitation Act is the proper framework to address these failures. And if the court does reach the merits of Mr. Pacheco's CAT claim, the court should also remand because the BIA legally erred when it ignored the thrust of Mr. Pacheco's claim. Beginning with the Rehabilitation Act, Your Honors, the agency failed in its affirmative duties under that act and the implementing regulations for 3 independent reasons. First, the IJ determined that a CDI, in addition to an ASL interpreter, was necessary when it granted the request, but then failed to follow through with that. Second, independently, the IJ at the merits hearing denied the CDI without undertaking an investigation as to his request and without giving primary consideration to that
Counsel,
request.
let's stop there. I've got some questions. So this does look like this is a failure at the IJ level. I don't know whose fault it is, but they clearly knew of his disability, had agreed to grant him a CDI interpreter. But once they get to the hearing and the IJ says, yeah, we don't have one here, do you wish to proceed? Your client is counseled. He's got a lawyer there. That's his advocate. And the lawyer consulting with the client that both of them indicate they would like to proceed. And your client affirmatively manifested to the IJ that he was prepared to deal with the ASL. So where is the violation here?
So a few responses to that, Your Honors. First, as a factual matter, Mr. Pacheco did not agree to anything. His counsel, in response to the IJ stating that they were not going to provide a CDI, said that he understood the agency would not provide a CDI, but that he could continue to raise communication issues. And we also know the issue wasn't resolved because the IJ.
This is on page 110 of the record. It's page 52 of the transcript. This is your client's attorney saying, I spoke with Mr. Pacheco. He understood that there wouldn't be another interpreter, but between him and this would be the ASL interpreter, they would let us know if there was any difficulty in communication. So even though Mr. Pacheco may not have affirmatively indicated to the IJ, he is represented by counsel who says, I have spoken with Mr. Pacheco and he would like to proceed today. So where is the problem?
So the problems are as a factual matter, as explained, and as a legal matter, because it's undisputed that he requested a CDI, and that put into effect the agency's burden to give primary consideration to the request and to conduct an investigation as to what accommodations he would need, even if it was not a CDI. So him agreeing to let the IJ know if there was going to be communication difficulties doesn't disturb that request. And the government also claims in response to the due process argument that this was a concession. But a concession has to be distinct and formal, and Mr. Pacheco stating he understood that there would not be a CDI is under cases like Santiago Rodriguez.
Okay. But is the problem here then maybe a miscommunication between Mr. Pacheco and his attorney? You haven't alleged ineffective assistance of counsel here. So the IJ is entitled to rely on what the attorney tells him. And the attorney told him that they understood that there would be no CDI interpreter. They were prepared to proceed. Mr. Pacheco is sworn in. The IJ says, if you have any difficulty in understanding things, please let me know. Pacheco responds to the IJ, I understand, I will do that.
So that point, Your Honor, there was not an IAC problem. This was at best a waiver, and the government has an obligation to prove that he intentionally relinquished his right to request a CDI. And under cases like Proa Tovar and Ubaldo Figueroa, counsel's statements cannot prove that waiver. It needs to be something that the IJ personally spoke with Mr. Pacheco and that he affirmatively responded to. And we also, in Duval, we also confirms the fact that Mr. Pacheco did not abandon his request for a CDI simply because the proceedings went forward. Similarly there, the plaintiff requested a transcription and his attorney renewed that request on the day of trial, but the judge denied it and the proceedings went forward. And this court didn't hold that forewent his challenge, and instead it reiterated that the IJ or the entity there had an independent duty to evaluate whether the individual needs are being met and then make a determination about that. And that's in line with cases like AG versus Paradise Valley as well. And so the acknowledgement of being aware about Mr. Pacheco, understanding that there was not going to be a CDI, or understanding that he was going to need to raise communication issues doesn't fall under a concession or admission that would bind him. And the BIA, although incorrectly...
So his attorney's representation to the court doesn't bind Mr. Pacheco?
Well, it was not a concession or admission that would foreclose his challenge to the CDI. And the BIA also construed that statement, albeit incorrectly, as his counsel failing to object to the interpreter, but Santiago Rodriguez also tells us that a failure to object is by definition not a concession or admission. The BIA was wrong because the IJ stated at the beginning of the hearing that Mr. Pacheco had requested a CDI. And as I was mentioning earlier, the IJ did not consider the issue resolved. He said that the parties would discuss if a CDI was necessary if Mr. Pacheco raised a communication issue, but that flips Mr. Pacheco's burden, or the agency's burden, onto Mr. Pacheco because it was the agency who had to give primary consideration to his request and explain why an ASL interpreter would instead be effective. And it's telling that the government construes this same colloquy in many different ways because it's trying to force a concession where there simply wasn't one.
There wasn't an objection. At some point, I mean, the opportunity to object was clearly there. It was not exercised. Did that mean they were going forward with a hearing that sort of like heads I win, tails you lose? That is, Mr. Pacheco couldn't lose at this hearing because he always had this ace in his pocket to say, oh, I get a do-over because they didn't have the right kind of interpreter here. An acknowledged mistake, but why isn't it the obligation at that point to say, well, I want what I'm entitled to, so we'll have to wait until the CDI is present? And that card certainly was not played.
The obligation was not on Mr. Pacheco because Mr. Pacheco, in fact, didn't have an obligation to make a request, a specific request at all. The court's cases in Updike and Duval make clear that the entity has an independent duty, regardless of Mr. Pacheco making a specific request, to make a determination as to what accommodations he needs. And it's only because Mr. Pacheco did make a request that the burden then does shift onto the agency.
So it really was heads I win, tails you lose. This hearing would be meaningful only if Mr. Pacheco won.
Well, what it was is a failure at the outset.
Is that the case? Is that the position you're taking?
No, Your Honor. What it was a failure of the IJ at the start of the merits hearing to undertake its independent duties to give primary consideration to his request. If in cases like
I take it your answer to my question is yes, that he could not lose at this hearing, he could only win.
No, because it's also...
Well, how could he have lost? I mean, he did lose, but you're arguing that that doesn't count. So you're basically telling me that the hearing proceeded with the understanding on Mr. Pacheco's part that if he lost, he'd actually get a do-over. He had an automatic do-over. That seems unlikely.
So what I'm asking is to just give the merit to give meaning to the agency's independent duties. And this is not a case where Mr. Pacheco then didn't raise his these communication issues at the BIA. He did raise these communication
And which
issues.
cases established the duty of the IJ?
Updike and Duval.
Okay, where does it say that in Updike? I've got that in front of me.
In Updike, the court said that the agency, or the entity there, had to undertake an investigation and make a determination, both in terms of what the request that the plaintiff there made. It had to put forth evidence that it looked into the availability of the aid.
But this clearly was an error by the IJ. I mean, somebody messed up at the IJ level. At the immigration court level, there's no disputing that. They should have provided him with a CDI. The IJ had done the right thing before, said, of course, we'll get you a CDI. But then the IJ says, we were unable to get one. Do you want to go forward or don't you want to go forward? If you don't want to go forward, we'll continue it. That was an easy answer. And it's just really difficult for me to see that Updike creates some huge obligation on the part of the agency to investigate all of this. It's a simple question. I told you that we would have a CDI here. I'm sorry, we don't have one. Are you able to continue or are you not able to continue? Yes or no, up or down?
Well, what's missing from that colloquy is there was no offer to continue the hearing. And it was simply, we're not going to provide a CDI. I'm going to punt the issue, the determination of whether you actually need a CDI, and instead ask Mr. Pacheco to go forward without it. And then if he can show that it's not sufficient, then he would be able to, then the IJ would.
The IJ also notes that prior to going on the record, we discussed this issue.
Right, and the IJ had a duty not only under the Rehabilitation Act to demonstrate what that issue discussion was, but also the IJ has a duty under the INA regulations to control.
So the question of continuance, counsel, I don't think you've correctly characterized the record. Again, I'm looking at pages 51 and 52. Mr. Stratton, this is the judge to his counsel. You're prepared to proceed today just with the ASL interpreter, and if it becomes an issue, we can discuss whether or not we need to adjourn to have the additional interpreter. Yes, Your Honor.
And yes, that Mr. Pacheco understood. A few moments later, his counsel said that Mr. Pacheco, in response to a different question, he said Mr. Pacheco agreed to let the other people in the courtroom. So that also is evidence that Mr. Pacheco was not acquiescing to the IJ's request that he move forward, notwithstanding his request. That was him understanding that that's what the card he was dealt. That's the option that he was given. And
can you, switching gears a little bit, can you briefly address the prejudice element? The agency found that Portugal has anti-discrimination laws that protect people with disabilities, and that those laws are enforced. So, what's the prejudice here? Obviously the agency erred by not having a CDI, but what would Mr. Pacheco have said that would have made a difference here, given the findings that the IJ made?
Right, so a few points there. With respect to the Rehabilitation Act, there is no need to show an additional harm. The cases are clear that the harm is the lack of a denial of the CDI or the lack of effective communication itself.
Have we ever applied that? That's one of the questions I had was for the Rehabilitation Act. Have we ever applied in the context of this? I mean, I understand the general due process one, but in the context of a IJ hearing that we have to redo it. Have there been cases on that?
When Updike, the court said it was legal error for the district court to ask to fault him for not showing that there was actual harm, or that there would have been a difference in the outcome of his process, which is essentially like a prejudice component. And so that's acknowledging that there does not need to be a change to showing that there would have been a difference to the outcome of the proceedings. And this is also consistent with, in Bax, the court adopted this Eighth Circuit standard in Silva, where in Silva, the Eighth Circuit rejected the notion that there would be downstream consequences. There needs to be downstream consequences to the lack of effective communication. And this is also consistent with other courts of appeals like in Luke and American Council of the Blind. And also there were, Mr. Pacheco was hindered in his ability to testify as to things that the IJ did rely on. So for example, his fear of future harm, his inability to communicate in Portugal or to live independently, and his access to medication or treatment in Portugal. Those are things that the IJ relied on to show that there was a lack of evidence as to his individualized risk of torture. And I see that I'm very short on time, so I'd like to
We'll
preserve
give you a
the rest of my
minute.
time.
Thank you.
Good morning. May it please the court, my name is Greg Kelch, representing the U.S. Attorney General. Mr. Pacheco, the citizen of Portugal, in his removal proceedings, he's seeking deferral of removal from Portugal under the CAT, for CAT protection. And Mr. Pacheco's claim has always been throughout these proceedings that he's afraid that, one, the government of Portugal may punish him for his rape convictions in the United States, and two, he will have difficulty assimilating into Portuguese society and getting medical care there. That has always been his claim. He was able to effectively communicate that claim during his final hearing before the immigration judge. That was brought out through, first of all, having appointed counsel for him, who is able to also lead his testimony, had the additional safeguard of leading questions. We do recognize that there are points in the record where his responses are not quite matching up with the questions that were given. But remember also that in addition to being deaf, he also has psychotic disorder. And that's what the forensic mental health expert was explaining to the immigration judge, that he has difficulty tracking a conversation and giving specific answers to specific questions. And you can see that also from some of the submissions that he has submitted himself to the immigration court. So he had a fair hearing. He had a fair hearing under the Due Process Clause of the Fifth Amendment, and he had a proper hearing under the Rehabilitation Act. He was brought to immigration court, and
So we sent this case back, is that correct?
that is correct, Your Honor,
For competency?
for competence.
And the question, and the answer was that he was competent or he was not competent?
The immigration judge found him not competent.
Not competent without counsel.
Without counsel.
Okay,
correct.
but he was competent nevertheless to testify and to understand the questions? Seems sort of strange, doesn't it, that we would find him not competent, but he's competent. He's not competent to be there without counsel, but he is competent to be there with counsel?
Well, this is a unique case because Mr. Pacheco hasn't been to Portugal in like over 50 years. He really has no firsthand knowledge about how
but
people like to be
competency
treated.
usually goes to your ability to be able to understand the questions and be able to answer the questions in your own defense.
Well, I think that for purposes of this hearing, what was required of him was an opportunity for him to express why he is afraid of returning to Portugal.
Right, but
And
if he's schizophrenic in addition to the deaf problem, that raises a lot of issues about whether this was really a fair hearing.
We think it is fair. He was assigned an attorney, also has helped him to present documentary evidence to the court about country conditions in Portugal, how deaf people are treated in Portugal. He provided letters from family members, letters of support from people in the community who knew him. We had a forensic mental health expert who came and explained his history of his childhood and his problems with hearing and how it affected his education. And I mean, like everything that we needed to know about Mr. Pacheco was explained, in immigration court.
It looks like there was a conversation, some kind of a sidebar before they went on the record. So we just don't know what went on. Do we know why there wasn't a CDI?
I do not know why.
Is that common in immigration proceedings? This is the first time I've seen a case involving a request for a certified deaf interpreter.
And I also, Judge Bobby, I have never seen a case before with a CDI. I will say that something that was said in one of the amicus briefs that we do agree with completely. In immigration court, interpreters are par for the course. We give people interpreters whenever they ask for interpreters. In fact, if you look through our trial transcripts, you'll often see cases where people come in and request a Spanish interpreter, and in the middle of their testimony, they start testifying in English. That happens all the time for us. It was not a problem to give Mr. Pacheco a CDI. It wasn't a financial problem, and it was not something that we feel would undermine our hearings. For whatever reason, they couldn't get the CDI that day. I don't know if that means that there was a personal problem with the CDI, because life happens. Sometimes something happens that people can't come to court. I see no reason for the court to conclude bad faith that the immigration judge didn't want to have the CDI there. We were trying to sandbag him. But, as your honors have noted, it happened. And when they showed up at the hearing, they had to make a choice. You had to go one way or the other. We could either reschedule this hearing, or we can go today with just the ASL interpreter. And Mr. Pacheco can let us know if there's a problem with the interpreter. And according to counsel's representation in his administrative appeal, Mr. Pacheco wanted to come to a decision on his case. Mr. Pacheco testified that he understood the interpreter. He said that multiple times. He never said that he couldn't understand his interpreter, or that he couldn't understand the court's interpreter. And also, his trial counsel at the end of his testimony, he'd asked the open-ended question, Mr. Pacheco, is there anything else you would like the court to know about your case? So if he didn't have understanding of the interpreter, if there was something else that hadn't been brought out, some additional reason to fear, return to Portugal, some problem he was having with his counsel, that was his opportunity to say so. There's just nothing in the record here, from our perspective, there's just nothing in the record here to really demonstrate that he did not get effective communication. It seems to us this was a pretty straightforward case. He's seeking cat protection from Portugal. So it's about the country conditions and evidence. And as we said in our brief, unfortunately for him, difficulty in accessing medical care and assimilating into society in Portugal is not a basis for cat protection. The denial of medical care only becomes torturous if it is specifically intended to cause torture to an individual. And of course, this court has seen country conditions far more dire than Portugal and found that cat protection wasn't appropriate. And then the other point, and I'm not sure how important it is, but what does the Rehabilitation Act apply to? Our understanding of it is that the Rehabilitation Act applies to the cat protection program. He should be have an equal opportunity to participate in cat protection. And that's what the agency gave him. The hearing itself is the application process. If he hadn't been in removal proceedings and he wanted cat protection, he would have applied for that through USCIS. But once a person's in removal proceedings, then you're before the immigration court. So, and we only raise that because Mr. Pacheco is arguing throughout his briefs that his participation in the hearing wasn't equal. But his participation can never be the same because he has psychotic disorder. It's always going to be a little bit different for him. I think the question should be, did he get effective communication at the hearing in his application for cat protection?
Well, it can't turn on the result of the cat protection, because that would suggest that unless you, in a criminal trial, you don't get protections unless you can prove you're innocent.
Agreed.
And so at some level, the question turns on the fairness of the process, not simply what the ultimate relief available to him would be.
Agreed. We do recognize that. So the issue here is, does he have effective communication in making his application for cat protection, not whether he actually is qualified to get cat protection. And I think, perhaps there's some smoking gun that I will find out here on rebuttal. But so far, nobody has raised any additional evidence, any additional basis on which he might be tortured in Portugal. Now, if there is some person out there who's threatening him, that would be different. But he testified that he hadn't been harmed in the past. Nobody has threatened him. Nobody is seeking him out. His only concern was that he called the Portuguese embassy, I think about 10 years prior to the hearing, to talk about it, and he felt like that person might hold it against him that he has 3 rape convictions in the United States. No country conditions evidence supports that conclusion that he would be punished again for what happened here in the United States. So that Judge Clifton would be the distinction that we're recognizing here. It's not For Rehabilitation Act purposes, we're not saying that he had to demonstrate that he is eligible for CAT protection, just that he has to demonstrate that he didn't get an effective communication in raising all of his bases to seek CAT protection. That's the distinction that we think is appropriate to draw. And then on that point, I do recognize cases like Duval, where this court has held that the Rehabilitation Act applies to court hearings. And as I was trying to distinguish in our brief, Duval is a divorce proceeding. There you have a husband and a wife who are essentially competing with each other for assets and potentially child custody issues. So there, if the deaf husband has to have an equal opportunity to make his case against his wife, because that's how the adversarial system works. But immigration court is different. This is applying for a benefit before essentially an administrative law judge. He only had to meet the minimum qualifications for CAT protection. There was no extra credit for showing that torture is certain to occur, just that it is likely to occur. And so for that, it's a little bit different in this context. He just has to have an opportunity to provide effective communication of his CAT protection claim. I'm not sure how much that distinction matters, but we think it is worth pointing out to the court. And if there are no further questions, we would ask that the court deny the petition for review.
Great. Thank you.
Thank you, Your Honors. A few points. First, as to the questions about whether or not he abandoned his request for a CDI, even if the court construes it that way, there are still errors because, first, as I mentioned, there was still an independent duty to investigate what accommodations he did need. And that's notwithstanding the fact that he didn't have to make any request at all. That duty stands regardless. A request is only a signaling function. And here, it's stronger because they had to give primary consideration to that request. And also, it doesn't cure the error of the fact that the ANSL interpreter he did receive did not provide effective communication. The government concedes that there were issues at the hearing, but blames it on his other disabilities, and that's precisely the crux here. The CDI would have facilitated communication where a hearing sign language interpreter could not have because of those other limitations. And so this response just illustrates the agency's failures to assess his disabilities as a whole. And I see that I'm out of time. Thank you.
Great. Thank you both for the helpful argument. The case is submitted.